I don't know.
701 and 701.1, Mr. Venu is an AOR. I have received instructions from him. Firstly, he is indisposed, can't walk, being 87-year-old. And
what we'll do is in all these matters,
yes,
the idea is to get these matters ready for hearing.
Yes.
So we'll pass a common order in all these matters
Fair enough.
in terms of the circular of the 22nd of August 2023, that the compilation of documents, the compilation of pleadings, documents and precedent, that must be all filed within, say, we'll give 3 weeks to everyone, and written submissions as well. And we will appoint nodal counsel in every matter, who will then prepare the common compilation. What we suggest is, instead of us really making a roll call,
We'll give the names of the nodal council.
everybody just gives the name for each matter, the name of the nodal council, so that their names will be included in the order. So that
My only request is if your lordships can tell us the dates, because unless we know, Mullah, we have to prepare ourselves for this. That your lordships should tell us in advance, that's all.
Certainly, what I'll do is, I'll prepare the calendar. I'll just look at how the calendar is situated for all the benches.
Correct.
And probably do that by this evening or by tomorrow evening.
Fair enough, fair enough.
That I can just sort of space them out. And if also on the same piece of paper, everybody can indicate, I mean, obviously these are not hard and fast, estimated time for the matters, because then I know how much gap to give before the next matter.
Fair enough, fair enough.
That may not be very accurate for the reason
Obviously,
that we don't have papers, we don't have the exact parameters of the matter.
Many of these matters have now been pending for 20 years.
Some of them can also finish in a day, Mullah. Some of them are very short matters also.
Yes.
Time limit is useful.
Yes.
Lord, there is one additional point as far as the tribunal matters concerned, which is 704, 705. What has happened is the referral order only refers to referring the money bill issue to 7 judges. But my lord, in para 118, the Honorable Supreme Court says the question as to whether all the tribunals should be shifted to an independent ministry has to be decided. This also should be referred to the larger bench of 7 judges. But in the concluding paragraph, that has not been added.
So we can, when we are formulating the questions, when the matter is called out, we can always reformulate a question and
Because
May I suggest, my lord, if it appeals to your lordships, but after, my lord, your lordships stipulated date for us to, my lord, keep our house in order, my lord, the numbering, etc., is done. If your lordships can keep the matters again for directions, some questions may have to be reframed. Your lordships may individually give dates. By that time, we'll be ready with the time schedule, my lord, which we will take.
Instead of doing that, because then after we give directions, again, they will go back,
They may
by
delay the
about
matter.
4 weeks. We'll give sufficient time here. So should we quickly call out each matter and just find out what each matter is, and then, not more than a minute for every matter. So
Fair enough.
just let's find, let's go with 701.
701, I'm for the, preparing for Mr. Venu Bhagat, who's for the appellant. He wrote a letter to the registry that he is unable to contact his clients whose firm is now defunct, and 2 of the partners have died. And the question involved, as he told me, was that whether there can be a sales tax on the sales tax for the goods sold, and is covered by a 6 judges bench of.
That has been referred to, 7.
Yes, that is why it was.
So we may still have to resolve the question, irrespective of whether, somebody is available or not. We may then appoint an amicus to assist the court on the issue.
I'm appearing for him in 2 appeals only.
And how many appeals are there in that batch?
I just,
There are 11.
yes.
Who's appearing in the other matters in 701?
That question arose under
There are 9 matters in 701. In 701, there are 9 matters.
11 matters.
11 matters. I stand corrected. Maybe something is added. Let's see.
No, not.
What about the other appeals? Is there somebody appearing in the other appeals in 701?
Yes, my lord. 701.
In 7, I am appearing in 7012, my lord, which is a matter of the state of Punjab.
For the petitioners?
That's
I'm appearing for the respondent, ma'am. 701.2.
And for the private parties, anybody else who's appearing? We'll list the matter sometime. So what we can do is maybe 701, we can list for directions immediately and then see if that really survives. If it doesn't survive, then we'll close it because now this is a legacy issue.
Very well.
All right. What about so we'll, 701 jo hai na, just keep it for direction so we can spend 10 minutes and see if that matter survives from Punjab. So two.
Lordship, please, sir.
The privilege is of the assembly, my lord, Tamil Nadu assembly. My lord.
That's,
I
that's
think the union
in that matter, that's the,
All the states.
All right, so there we will
that's
give
the power
direction.
of the speaker to arrest, that's the issue.
Right. We'll give directions then, the usual directions in that matter.
Only one request, please.
Your Lordship issued notice to the Attorney General to assist the court in this matter. So that's why I'm here.
But, my lord, in few matters, though union has something to say, we are not parties. If your lordships can pass a general order, implementing union as a party, we'll waive. We don't wish to delay the serving, etc.
But you can, anyway, we can assist the courts
it's in
independent of that.
704.
We'll permit.
Formal that may be necessary, my lord, for us to file pleadings, etc.
All in the entirety of.
No, there are 2 or 3 matters where we are,
Or
no
the
necess-
speaker has nothing to do with the union.
But if we require some assistance from the attorney.
Okay, here I have no problem, but otherwise, whether it's an issue.
Anyway,
between
notice
the
has been
speaker-
issued to the Attorney General.
That's-
We will say that on the we'll permit the union
No
to be
problem,
implemented.
I don't say that, but
Let them be there. We'll have some more assistance
No
assistance
problem.
on this side as well.
no problem.
I appear for the,
To amend the,
in 702, I appear.
to impede the Union of India. Mr. Tushar Mehta, Learned Solicitor General, appearing with that no further notice
Will
is
do.
required. On 701, 702. Just make sure that all the names are, yes, they will clarify that.
That I appear for the speaker of the legislature.
All right, so we'll give directions for listing 702. We have a few CBs which are already listed immediately, and immediately after that, we will take up.
Fair enough, fair enough.
All right.
703.
My Lord, as far as this is concerned, this is the Aligarh Muslim University matter.
Minority status.
Now, there are two directions your lordship would have to pass. The first is in the High Court, notice was given to the Attorney General. So that may be done in this case as well.
Like notice to Attorney General.
The second is a little more complicated. The union supported the minority status both before the single judge bench and division bench. They filed an appeal against the division bench order which said that they are not a minority. They have now filed an affidavit in 2016 saying that they want to withdraw their appeal. Now their status would have to be determined whether they would be respondents.
That
because
is
they-
when it is called out, my lord. That's a contentious issue.
Apart from the appeal by the union, who else has filed an appeal? There's other appeals as well.
The university itself.
There are 8 appeals, 5 by AMU, that's the university, and 2 by private parties. But this issue has to be decided,
This will have to be
This will
decided.
have to be decided, yes.
and it can be decided as a preliminary
No,
issue.
we'll have to decide the issue.
Yes.
When the matter is called out, we'll see what the
That's
impact is.
And notice to the Attorney General.
With that, we've already issued.
I'm already here.
Lord, what I've done in this is I've framed 5 issues which can be uploaded to your lordships. Can we just put that down?
If you can share it with us, we can.
Dr. Dhawan, if you could share it with the Attorney General, so that, then they can respond to you, and when the matter is called out, we can, before we begin the hearing, we can finalize it.
I've already uploaded it, my lord.
So kindly serve a copy on this. That's the request.
Absolutely, we'll argue it.
Very well.
704.
704, I appear for the state of Punjab. Because here the issue is that subclassification within the scheduled caste, the state had
Chinnaiya.
passed.
Chinnaiya.
That's right. So Chinnaiya has to be relooked at. Because the learned advocate general of the state is also appearing online. So Malaz may appoint Malaz from our side, Mr. Karan Sharma as the nodal counsel.
So, as I said, in all matters,
We'll give the
please
names.
give the two nodal
My
councils.
lord, instead of troubling your lordships.
This matter will require hearing, my lord, because we have a category of Valmikis within the scheduled caste, my lord, which was under challenge and the High Court has squashed it. So we are in appeal.
What we can do is that we are circulating soft copies of everything now. So your note, your written submissions, etc., can be formed in a compilation, and the two nodal council will put everything together for every matter.
Nice.
Not necessary right now because it will just get lost in the papers. So it'd be much better that you give it to the nodal council so that they are uploaded, and then we have everything down in one compilation.
We should be 704. In fact,
Yes.
in 704, I had appeared before the 5 judges bench for a private.
This,
court.
that
I
money
think
bill issue.
It's a matter of importance where the union may have to be heard.
No, this is the money.
Union may be implicated.
704 is going on.
704.
Yes, yes.
Union may be implicated. We'll waive that.
And 705 is the money bill.
705 is the reference in Roger Matthew.
Yes, now that's something that should be decided, Malaz, that's my request. Malaz, give it priority because that's a really live issue, Malaz.
All right, we'll.
That's my request. It cuts across, Malaz. But there are several,
We'll give that some priority, Mr.
The priority is your lordship's discretion. We would request your lordships may go, my lord, seniority. It's entirely my lord's discretion.
That's your-
We cannot have it. We can't decide priority
we
based.
can't argue on this, Malaz.
All right, we'll leave it to us. We'll take up that.
I appear for the respondent, my lord, 705.
We
It has
can't decide priority based on political exigencies. That's all.
that your lordship will decide, Lord, which.
Please decide, Malaz. I think there is some.
Well, 705, there's also an amendment by the.
706 is Subhash Desai, Malaz, that issue.
Where we referred it
That
recently.
only requires half a day, Malaz. That's not really, not a matter that will last very long.
Not very long.
Yes.
That's the review of the legal of Nabam Rebia.
That's correct.
Yes.
Nabam Revi agenda.
So
Are you
that,
going to really press that issue, the reference of Nabam?
they should accept what we are saying, Malaz. This is not a matter, Malaz, that. This is,
We'll see whether.
yeah, that's clear, Malaz. That's the whole issue is very clear. It'll take only half a day, Malaz. That's it. Very clear.
901.
Excuse me.
Please, madam. 901, my lord, there are two sets of matters, one relating to MADA challenge to Chapter 8A, and one relating to the Maharashtra Rent Control Act. Which came
Right.
up. So there are a series of orders which 3 judges referred it to 5. Then
5 to 7 and 7 to 9.
my lord.
But now that has to be resolved one way or the other.
That's it. That's it. Interesting questions on interpretation of Article 31C, 39B.
Yes, Mr. Attorney.
There I left you appear for Mada and the.
I am for the state of Maharashtra.
Just
Yeah.
the court appeal. Yes.
902.
So we'll again pass the same order. Please, before leaving, give us a list of nodal council because the whole
Yes.
purpose of this hearing is to get the matters ready for hearing in the next 4 weeks or something.
Well, in 901, I have circulated a note giving a background of those three orders, which were 3 to 5 to 7 to 9.
All right.
And because the reference has not been made specifically to any issue, well, let's kindly look into that note so that it can be taken. Great.
In 902.
902, I'm appealing for the petitioner.
11 issues, my lord.
Appellants.
What is the issue?
It's about the
India
land
Cements.
tax which was imposed on landlord, mining land, mineral land.
Under state.
Tax on royalty.
So it was cut down based on India Cement
India
was
Cement,
saying
yes.
as royalty is tax and therefore. And then Kesharam came subsequently where I also appeared, Lord, and then they distinguished that. Then subsequently in our case, Lord, Justice Kapadia, Chief Justice Kapadia, Lord, he said, Lord, that there is a conflict between 7 and 5 and therefore.
Therefore, it's gone to 9.
My lord, one other thing in 902, apart from the 11 questions, what is actually the burning problem now? If your lordship holds that mining royalty is a tax, then the additional consequent question is whether you can levy service tax and GST on that tax. That is pending in Jodhpur, Madras, Assam. Against all the petroleum companies, we are paying royalty. And on that, they are demanding GST and service. Amounts have become very large now. So at the early,
But this has to be resolved early. It's been pending for almost 20 years.
24 years.
Yes, the area is mounting, my lord, that's the problem.
And it's not good for anybody ultimately that these tax users.
Milord,
There will be
may I
a
say
problem
one
with
word,
payment
Milord?
also,
May I
if
say one
it
word?
goes in our favor.
Milord, subsequent amendments in MMDR.
because that what happens is on royalty, we pay GST service tax, and that is not be able to set off to the consumer. So it's a cost to the oil companies.
All right, we'll list this. We will certainly give this priority in the 9 judges because it's in a 9-judge complex.
Yes, 9 judges.
Pending since very long, Milord, 2011.
So this is a question relating to industry.
Yeah, section 2J of the Industrial
Area of
Disputes
the
Act.
industry. Now, the referral order is not very clear to us with respect. Now, the issue there in Bangalore water supply was with reference to municipal corporation. But the court has undertaken the task of examining whether education is an industry, sovereign functions.
Clubs, whether clubs are industry, sovereign functions, Punjab polls,
Bangalore water supply.
Bangalore water supply, 78 Supreme
So
Court.
the Cricket Club of India, all those judgments were reviewed, which in my respectful submission were not within the scope of Bangalore water supply on the facts of that case. But since now it is referred to larger bench, whether we are permitted to address the court on all issues or whether with reference to the sovereign functions of the state, because it's
The Department of Narcotics is held to be an industry. So it,
I'm concerned with Forest Department for the state of Maharashtra.
And Forest Department also, there are a large number of cases across India, irrigation department, Forest
State
Department.
of UP also.
Even university, then we get into a Bangalore water supply.
Of course, Bangalore water supply now has stood the test of time for almost 45
It takes
years.
some time,
So
because if the entire judgment is to be revisited, then it will take some time.
we take a call once the matter opens as to whether, it's desirable that a judgment which has held the field for 45 years should at all be reviewed. Or what is the great public injury that has happened now as a result of that?
Lordship can fix it between the Dussehra holiday and Diwali holiday, in between that.
We'll
In which case, I think union may have to be heard on the.
Yes.
the industry.
So we'll issue notice to the
they are
attorney.
not a party.
And here also include the Union of India.
Well, Lord, in fact, the law has been amended. So there is no need for this matter to go to a larger bench, Milord. That would be my submission.
That you can argue when the matter is called out.
May I mention the matter, Milord, of 2006, which was where I've been referred to be taken up along with this, the main matter, Milord. My matter is not listed. So may I request that this,
Has that been tagged with the 9 judges bench matter?
well, it's supposed to be taken up after the judgment of the 9 judges bench. Milord, this 2006 matter, I'll address your
Let's do
lordship.
this. Give a small note to the registrar listing who is in the court. And I'll take a call on whether this has to be placed with the 9-judge bench. Just give it to the registrar.
Very well.
By the evening, give it to him. I'll take a
Yes,
call.
by this.
Issue administrative.
Yes, much.
Yes, Lord, we are appearing to the state, Lord, in this matter, Lord. Then the issue is with regard to the state's jurisdiction to regulate industrial alcohol.
Synthetics.
Oh, synthetics and chemicals. Justice Sabyasachi Mukherjee judge.
I'm appearing for the
Lord, there is one, we all appearing. Lordship may have to make the union as a party because it's between.
I think union, I have to be heard.
Yeah, we'll should.
Yes,
And wait.
They're not formal parties.
Yes.
There was one more request, Lord, if Lordship's deem it necessary. Because for the states, it's an important matter. Their power to regulate has been taken away by synthetics. Now, Lord, in this synthetics itself, the Supreme Court considered all the states, Lord, then all the states participated and argued the matter vis-a-vis the power of the union and the state. So what we submit with respect, subject to what Lordship decide, Lord, would it be appropriate for Lordships to, Lord, call all the states over, notify them?
What do you say, Mr. Attorney? Notice to all the states in this?
Or it can be verified. Lord.
Yeah, then all the states.
They are.
Can it be on the website?
Say that liberty to, notice shall issue to all the state governments and the governments of the UTs as the case may be. Liberty to serve the standing council. Notice shall be served in the standing council for the respective states stroke UTs.
My lords, they are.
Lord, the notice to the Attorney General has already been sent, has been given.
But they have not been tagged. So we can provide with the list of those appeals which are pending, which may be tagged with this
we can do that, or we'll hear the states here and this judgment will follow and,
SSPs have to be also heard in the.
all right.
My only reason was not since in the
No,
earlier.
if you're right,
judgment, all was
really, we have to hear the states. States are vitally concerned. It's really essentially a turf, constitutional turf between the union and the states. Because the law is, potable alcohol is in the jurisdiction of the states, industrial alcohol, the center. But the states can pass legislation or regulations to ensure that there is no diversion of potable to industrial alcohol to potable.
That's
Denatured.
the problem. Lord. The problem is otherwise. Lord. If Lordship could see till 1990, states were regulating industrial alcohol as if it was a privilege. It was 1990, this privilege theory was not exploded and the state's power was taken away by the center because IDR Act came in.
My lord, in fact, subsequently in 2005, the IDR Act has been amended and potable alcohol has been excluded from IDR. It's only the industrial
The
alcohol.
issue is, can you do it in IDR or the state's exclusive jurisdiction? How can you take it in IDR?
We'll have to see.
We'll ask.
Okay.
Lord, before your lordship takes that matter, Lord, there is one confusion, if your lordships can grant indulgence. All of us are making this request. My lords have fixed one 7-judge bench matter, my lord, on 5-judge bench on 17th. Well, that is that Assam section 6A validity matter, my lords. But yesterday, my lord, we were informed that the entire week is a miscellaneous week. All of us are appearing, my lord.
That will now go to the 7th of November.
Please,
7th of
that's
November.
all we, my lord.
7th of November.
Milords, may I make one small request, Milords? Milords, I'm here, Milords. Milords, in 703, Milords, would the registry be able to provide us with all the pleadings in the pen drive form, Milords, because that becomes easier. These are very
All
old.
matters, my lord, if
The
that-
courtmaster just told me that he's adding that as one
Grateful,
sentence in all orders.
In
The
all
registry
matters.
will provide soft copies to all the
Lords,
councillors.
in that regard only, Lords, I have to just make a submission, Lords. I had the occasion to go through some of the scanned records last night after the list was uploaded. There are certain, Lords, it is very convenient for us to actually download it from the e-filing to portal. But some of the scanned digitalized files have a watermark of draft or something else written in the entire paper.
That watermark will go now. In fact, that was pointed out to me last night by the registrar IT. He said, sir, there's a problem. We have scanned this file. Some of them have watermarks. They're dealing with it. Don't worry. In fact, it was brought to my notice last night before I was
In
leaving.
902, Lords, I have one more additional submission to make. Lords, there are 6 transfer petitions in the batch. Lords, the batch has grown from 41 to 84 matters in 902. And Lords, 6 transfer petitions, 6 SLPs, then 4 writ petitions and 68 civil appeals. So Lords, transfer petitions, the main substantive challenge is pending somewhere else. In that regard, Lordship may have to take a call whether
to allow the transfer petition and bring those matters.
Yes, that should not delay the.
Yes,
hearing.
can you do one thing? If you can give the courtmaster the list of the transfer petitions.
Yes, I have.
I'll list them for directions independently on some day. So that then everybody in those transfer petitions will be here and we'll take a call on what to do in those.
What can be done, either to segregate them and.
They are with the judge.
Allowed to intervene only, that.
Instead of bringing everybody here. That may
Otherwise,
be altogether
Allowed
better.
Just to intervene if they.
Somebody may seek
If
time
somebody
to
wants
file
to
reply,
intervene, they can
etc.
argue the question of law, assist us in the question of law. Fair. I think that's better.
And the question whether even if the main contract is null and void, whether an arbitration agreement survives, to consider that very question is directly covered by 16(1)(b) expressly. 16(1)(a) is separate, the arbitration clause is separate, and 16(1)(b) directly covers the issue. Now, very briefly, therefore, whether the first argument is whether or not it is invalid, it goes to even existence, or whether it is only an irregularity or a curable defect. I'll come to that later, but assuming it is the worst, it's an invalidity. Even then, my submission is, by virtue of the doctrine of separability and competence, which I act fully now recognizes, these are issues that must be left to the arbitral tribunal. And I'm going to save the court's time. I'm not going to take my lords through each of the judgments, but I've summarized from my revised submissions are now found in volume 1B, page 2. And from page 7 onwards of volume 1B, I've just extracted some of the major decisions, internationally as well as ours, on separability. And to which, of course, I'm going to add one when I show it before my lords. Page 7 of volume 1B. It's been added last night. Been uploaded now. My earlier submissions were in volume 1, but since we made a change, there was one mistake which we corrected.
Over here, it's updated submissions.
Updated submissions. I'm aware.
There are 38 pages.
38 pages. But that's because I've extracted judgments there, so it's easier for me to read from there rather than troubling my lord to go to the actual judgment. I'll be going to the actual judgments in only 2 cases, which are quite critical.
Is it Harbor Assurance Company?
Yes, it starts with that.
That's the Queen's Bench decision.
That's right.
Oh.
It starts with that Court of Appeals.
Yes.
Yes. If my lords just see para 9 onwards, Harbor Assurance arbitration agreement is a self-contained agreement. In Involnat, it was held that it's a self-contained agreement which is separable from the main contract, therefore has autonomous existence. In our own Enacon, expressly under section 16, your lordships have held that section 16 accepts the concept that the main contract and the arbitration agreement form 2 independent contracts. And then in para 83 again, the Supreme Court calls the arbitration agreement a second contract. Redfern and Funto also speak of 2 separate agreements, primary or main contract and a secondary contract. Then if we go straight to para 14, Gary Bond, the arbitration agreement may exist and be substantively valid, notwithstanding the non-existence, invalidity or illegality of the underlying contract, and the arbitral tribunal may and must consider challenges to the existence, validity or legality of the underlying contract because such challenges do not impeach the arbitration agreement. Then Fiona Trust. Arbitration agreement must be treated as a distinct agreement and can be void or voidable only on grounds which relate directly to the arbitration agreement. These are all very well settled principles, so I'm not troubling I'll just quickly go through this. Now, next page, again, the validity of the arbitration agreement is not undermined as a distinct agreement. The US Supreme Court has also taken the same line in Buckeye check cashing, which your lordships have followed. That despite the invalidity of the underlying agreement as a whole, arbitration agreement will continue to be enforceable apart from remainder of the contract. Para 17, page 11. In Ayaswamy, your lordships have held that the adjudicatory power of a tribunal remains unaffected by any objection to the main contract. And in Vidya Drolia, which I have not mentioned here, but which I noticed, my lord, during the hearing, which I'll be showing, again, paras 173, 174, expressly say arbitration agreement is a separate contract in itself. The Singapore position, which I've set out from paras 19 to 22, 23, really says the idea is to insulate the arbitration agreement, even though it may be integrated into a main contract, from objections as to invalidity of the main contract. So the law of separability is very, very well entrenched in our law. And my lords will notice that both in Ayaswamy and in Vidya Drolia, separability is spoken of as a concept which actually permeates the Arbitration Act. It goes beyond just matters where there is a challenge under section 16 to a decision of an arbitral tribunal. So although the legal fiction, if I may call it that, in 16 is for the purpose of giving the arbitral tribunal jurisdiction to decide its own jurisdiction, it is not restricted to that. It's a wider principle recognized under our law and under section 7.2 and 7.5 independently of 16. Now, the only reason I say that is that with this, squarely any such issues, whether we call them existential issues, whether we call them only irregularities or curable defects, must in the first instance go to the tribunal. And your lordships are always there at the stage of the award or the order, whether under 37 or 34, to have a look at how the tribunal has exercised its jurisdiction. I have also set out at page 14 of my submission, section 5 of the Indian Stamp Act. This is really a matter ultimately that the tribunal will go into, but just for completeness. Section 5 of the Indian Stamp Act recognizes a position that a single instrument may pertain to several distinct matters. And in which case, according to the Stamp Act,
This is the second point you're making.
it's really part of this separability point. If it pertains to distinct matters, the aggregate of the stamp duties on each of those distinct matters must be worked out. Now, if an arbitration agreement is separable, then perhaps a tribunal may be persuaded to hold that there must be separate stamp duty and all. In other words, separately on the arbitration agreement, which is what your lordships have held in NN Global under the residuary clause, as well as substantively on the value of the main agreement. This, of course, is a matter for the tribunal. I'm not suggesting my lords should decide this. My lords have made it clear your lordships are not deciding chargeability. But I'm only placing it before my lords because this is how the issue will come to be decided. And at para 29 of my submissions, I've referred to your lordship's judgment in Chief Controlling Revenue Authority, which affirms a passage from Halsbury in relation to Section 5 of the Indian Stamp Act, that an instrument containing or relating to several distinct matters is to be separately charged as if it were a separate instrument. So even under the Stamp Act, there is some concept of separability. Now, it may be that a tribunal takes the view that no, stamp is payable only on the whole. Or it may be that it takes the view that it's payable separately under each. That's a matter of chargeability. But that decision, in my respectful submission, must be by the tribunal.
Forum is the only issue.
It's the forum which is an issue.
This is the forum.
Did it happen, not happen?
Precisely.
The whole purpose is to shift the forum to the arbitrator so that arbitration proceedings don't get delayed at the threshold. You go there and then you argue it out if something is the consequence that is there. But the court under 11.6 is the only issue really which we are touching.
That's it. Now, my lord, for that purpose, I want to show my lords two judgments, which my lords have seen, but I just want to emphasize certain different aspects of them. The first is my lord's decision in the Ayasami case, which my lords will find in volume 5A at page 1336. There are three important principles laid down here, which I want to just, press into service.
3,000?
1336, page 1000 of volume 5A. This is 2016, 10 SCC 386. My lords would kindly turn to page 1359, para 33. Para 33 says, Section 16 empowers the arbitral tribunal to rule upon its own jurisdiction, including ruling on any objection with respect to the existence or validity of an arbitration agreement. Very important because existence, even assuming stamp goes to existence, it's housed with the arbitral tribunal under 16. 16(1)(b) stipulates that a decision by the arbitral tribunal that a contract is null and void shall not entail ipso. Yes. 16(1)(b) stipulates that a decision by the arbitral tribunal that a contract is null and void shall not entail ipso jure the invalidity of the arbitration clause. Hence, the invalidity of the contract between the parties does not render the arbitration agreement invalid as a consequence of law. This recognizes as inhering in the arbitrator the jurisdiction to consider whether the main contract, other than the arbitration clause, is null and void. The arbitration agreement survives for determining whether the contract in which the arbitration clause is embodied is null and void, which would include voidability on ground of fraud. The severability of the arbitration agreement is a doctrinal development of crucial significance, for it leaves the adjudicatory power of the arbitral tribunal unaffected over any objection that the main contract between the parties is affected by fraud or undue influence. My learned friends, for the respondents in their submissions, have argued long and hard that the doctrine of separability should not be applied to a stamp issue. If that is so, even then, by virtue of section 16, that issue must go to the arbitral tribunal. The next para is para 46 at page 1366. I'll just read a small portion of it. At page 136, at para 46, my lords have cited Fiona Trust. And then at the bottom, placitum G. Arbitration must provide a one-stop forum for resolution of disputes. The Court of Appeal held that if arbitrators can decide whether a contract is void for initial illegality, there is no reason why they should not decide whether a contract is procured by bribery, just as much as they can decide whether a contract has been vitiated by misrepresentation or non-disclosure. So the second principle is also accepted in the Vidya Drolia judgment of a one-stop forum for adjudication. Deciding a stamp objection in court before making a reference will violate this principle as well. And your lordships have given the reason underlying para 46 in para 48, which is 1367. The basic principle which must guide judicial decision making is that arbitration is essentially a voluntary assumption of an obligation by contracting parties to resolve their disputes through a private tribunal. The intent of the parties is expressed in the terms of their agreement. Where commercial entities and persons of business enter into such dealings, they do so with a knowledge of the efficacy of the arbitral process. The commercial understanding is reflected in the terms of the agreement between the parties. The duty of the court is to impart to that commercial understanding a sense of business efficacy. So the second one-stop business efficacy, parties intended that one forum would decide all their disputes and it would not be split amongst different forums. And the third principle, a more general principle in para 53, 1369. The Arbitration Act should, in my view, be interpreted so as to bring in line the principles underlying its interpretation in a manner that is consistent with prevailing approaches in the common law world. Jurisprudence in India must evolve towards strengthening the institutional efficacy of arbitration. Deference to a forum chosen by the parties as a complete remedy for resolving all their claims is but part of that evolution. Minimizing the intervention of courts is again a recognition of the same principle. And the principle, of course, as we have seen, is housed in section 5 of the Arbitration Act, which has a very far-reaching non-obstante any other law. So that is Parliament's legislative intent reflected in section 5. Therefore, these are three principles. Now, these three principles and two more have also been categorically affirmed in the Vidya Drolia decision of your lordships, which is to be found in volume 5A, page 76. The 5 principles that I rely on Vidya Drolia for, first is separability. Second is full competence, that is both positive and negative. Third is the prima facie test. Fourth is that even under 11(6)(a), only the contractual validity of the arbitration agreement is to be seen. In other words, coupled with the prima facie test, if the court is prima facie satisfied that there is an arbitration agreement within the meaning of the Arbitration Act, then that is all. Nothing more has to be seen under 11.6a. And the fifth is these principles of a broad pro-arbitration interpretation to respect party autonomy and one-stop adjudication, presumption of that. These are the 5 principles that have been laid down in Vidyadrolya. And may I quickly run through the paragraphs? Both the learned judges have decided this. The judgment is found at page 76, 2021, 2 SEC page 1. First, para 126, if my lords would kindly go to.
Which volume is this? 26 is it?
At page 182. 5A, 182 is para 126. First is separability. I'll just show both the judgments are ad idem on this. Para 126. Page 182 of volume 5. My lords have it. Yeah. Para 126 covers both separability and competence. We would now examine principles of separability and competence. Clauses A and B to subsection 1 of section 16 enacts the principle of separation of the arbitration agreement from the underlying or container contract. Clause A, by legal fiction, gives an independent status to an arbitration clause as if it is a standalone agreement, even when it is only a clause and an integral part of the underlying or container contract. Clause B formulates a legal rule that a decision by the arbitral tribunal holding that the main contract is null and void shall not ipso jure entail invalidity of the arbitration clause. Successful challenge to the existence or invalidity or rescission of the main contract does not necessarily embrace an identical finding as to the arbitration agreement, provided the court is satisfied that the arbitration clause had been agreed upon. The arbitration agreement can be avoided only on the ground which relates directly to the arbitration agreement. Notwithstanding the challenge to the underlying or container contract, the arbitration clause in the underlying or container contract survives for determining the disputes. The principle prevents bootstrapping, as it is primarily for the arbitral tribunal and not for the court to decide issues of existence, validity, and rescission of the underlying contract. Principle of separation authorizes an arbitral tribunal to rule and decide on the existence, validity, or rescission of the underlying contract without an earlier adjudication of the questions by the referral court. Para 173 and 174 are the equivalent findings on separability in the second judgment, page 200 of volume 5A. Arbitration is a creature of consensus. It is completely dependent on party autonomy and the intention expressed in the agreement. A contract having multiple clauses, including arbitration agreement, can be divided into 2 parts. The clauses relating to the commercial relationship, i.e. obligations and duties of each party, can be referred to as the main contract. The arbitration agreement, so to say, is a separate contract in itself. And then His Lordship finds that separability of the arbitration agreement from the main contract historically existed even in Roman law and later, of course, in German and Swiss jurisprudence. Now, competence. Again, para 126, I've shown my lords. Para 129, if my lords will also kindly see, is also very instructive. At page 183. Principles of competence have positive and negative connotations. As a positive implication, the arbitral tribunals are declared competent and authorized by law to rule as to their jurisdiction and decide non-arbitrability questions. In case of express negative effect, the statute should govern and should be followed. Implied negative effect curtails and constrains interference by the court at the referral stage by necessary implication in order to allow the arbitral tribunal to rule as to their jurisdiction and decide non-arbitrability questions. As per the negative effect, courts at the referral stage are not to decide on merits, except when permitted by the legislation, either expressly or by necessary implication, such questions of non-arbitrability. Such prioritization of the arbitral tribunal over the courts can be partial and limited when the legislation provides for some or restricted scrutiny at the first look referral stage. Now, this is a judgment, I believe it's the first, which divides up even negative competence into express and implied, and that is correct, because very often a section will not actually say a court should not interfere. But an interpretation of that section, given Section 5 of the Arbitration Act, leads to an implied negative competence or a stepping back, as it were, of your lordships at the first stage. Because the whole scheme of the Act, the architecture of the Arbitration Act, is geared not towards front-loading inclusion by a court at the beginning, but towards a scrutiny after an award is passed. So it's not the arbitration that is heavily supervised, it's the award that is looked at when it is challenged, or of course an order under 37, if there's an appeal. And the same thought permeates through paras 178 and 208. I won't read them. No, the equivalent paragraphs, I won't read them, are para 178 and 208 in Justice Ramana's judgment.
178 and 208.
178 and 208. The third principle, and this note I want to place, because this is the prima facie test. We have heard a lot about Section 8 is only a prima facie approach. What is a prima facie approach? How does a court apply it? Para 147.11, page 194, tells us how to do that. the second sentence, the court as the judicial forum of the first instance can exercise prima facie test jurisdiction to screen and knock down ex facie meritless, frivolous and dishonest litigation. Limited jurisdiction of the courts ensures expeditious, alacritous and efficient disposal when required at the referral stage. So something which is ex facie meritless or frivolous. Ex facie, there is no arbitration agreement. That is something alone that a court will see under 11.6a. The rest, if there's even a dispute or a doubt, will be sent to the tribunal. When in doubt, refer, is what this judgment itself says. And a similar principle, I'll just mention the para number. At para 154.4, at page 196.
That's what we have said, even in the case of limitation, if you get a case under 11 where somebody's come after 10 years, 20 years, or something doesn't turn really on a very detailed interpretation.
On a demurrer.
Demurrer. Justice, I think, Justice Narasimha and Justice Pardiola were sitting with me when we found a case like that. And then the whole object of sending parties to arbitration again it defeats the purpose of arbitration.
So without much inquiry, without determining some heated controversy between the two parties, if a court can ex facie see it, of course, that is a safeguard under 11.6a. No one is disputing that. But stamp will never be such a question, particularly because, as we have seen, it's a curable defect.
Bhavata, that's the whole thing, this Stamp Act. Anything to do with stamp. If it has a possibility of being curable.
Yes.
Let us say even recognize the possibility of being curable, then how do you throw it out at a threshold?
I bow to that. My lord is absolutely correct.
So, in any scenario, possibly, Stamp Act requirement in any formulation of it, any variation of it, I'm very doubtful whether at all it can be looked into.
My lord is right.
11.6.
I'm going to place a judgment of your lordships on that immediately after I complete this, showing that it doesn't, irregularity in stamp or even non-stamping doesn't render a document invalid. Your lordships have held that. I'll place that. But very quickly, I'll just give the paras on this. I won't trouble my lord. But the equivalent para is para 232, Justice Ramanna's decision, where he expressly refers to section 8. That is at page 234. And he says in para 233 at page 235 that the defendant has to establish prima facie case of non-existence. It's the other way around. The defendant will show that ex facie there is no arbitration agreement. Well, the fourth proposition, again, in the interest of time, I'll just give the paras. Paras 236 to 238 at pages 235, 236, relying on your lordship's Mayawati decision. Ultimately says it's only contractual validity of the arbitration agreement that has to be seen under 11. In other words, section 7, is it complied with? On the face of it, ex facie. If there's again, even on that, if there's a dispute to be gone into, it will go to the tribunal. But if ex facie, your lordship is fine. There's just no agreement, of course. And para 244.5 and para 146. They all go on the basis of this kind of validity. And my lord, I adopt Mr. Datar's submissions. I'm not going to repeat them. Under the Contract Act, what is not a valid contract or what is a void contract is only one which is voided under section 23 or under section 10. Nothing more than that. Stamp Act doesn't come into that at all, not even into the Contract Act.
We have elaborately at this moment.
Yeah, so I'm not touching that. I adopt that, my lord. And the fifth, my lord, set of paras in this judgment, I'll just give the para numbers. Paras 151 to 152, page 195. And para 220 at page 230 is again the principles of a broad pro-arbitration interpretation and a one-stop forum for adjudication.
What is the latter para?
Para 151, 152.
195.
At page 195 and para 220 at page 230. They speak of a one-stop adjudication presumption. You start from the presumption that everything goes to the tribunal. Now, applying this to 11.6a, it's not that because the word existence is used, everything coming under that umbrella of existence has to be gone into. The legislature has said confined to the existence, and given the principles under Section 5 and these very salutary principles of law, a court would restrict by way of an implied negative competence, even under 11.6a, to an ex facie examination. Now, my lord, this is more so because of the next point, which has been argued. I'll just point out what I think is relevant and which has not been shown to your lordships. Under the Stamp Act, 1, non-stamping or understamping does not result in an invalidity or voidness. And 2, it is a curable defect. Now, if my lords kindly turn to my written submissions, volume 1B at page 15, I won't read all of them.
It's also waivable. You can waive it because.
And one can waive it. My lord is right. In fact, there are 3-4 sections which I want to just point out. Again, I won't read them. They've been read. Barring one, they've been read to my lord.
Waiver is also by conduct. It's far more liberal. It doesn't have.
My lord is absolutely correct. And if that is so, then under 11.6a, how will a court go into that? I'm obliged. I'm obliged. May I, my lord, adopt that as my submission? I think that's very well put. In fact, as Mr. Banerjee also argued, an 11 court is not even a 2-1e court. Whether it can take evidence is also a question. But therefore, it's impossible to go into these disputed questions under 11.6a, despite the use of the word existence. That has to be read purposively as meaning only ex facie if there's non-existence. There's a probability of existence, it must go to the tribunal. Now, curable defect and invalidity. The first point, Section 35 is very clear. It visits a non-stamped or not duly stamped instrument with only 2 consequences. One is it is inadmissible in evidence. And the second is it shall not be acted upon. And my learned friends have emphasized the second, not be acted upon. And they have tried to elevate those words to unenforceability leading to voidness and invalidity. I'll presently show why that can never be so. The curable, where the defect can be cured is Section 36 we have seen, where once an instrument is already admitted in evidence, no stamp objection can be taken to its admissibility later. Section 37 and sections 42, which I don't believe have been shown, 42 I don't think has been shown to my lords. But 42 only allows the collector on payment of duty and penalty to stamp the document, and after stamping, then it can be admitted in evidence, and the shadow, as it were, of Section 35 is lifted. In NN Global 2, and Mr. Datar has pointed this out, there's a slight contradiction because in para 108, it is said this invalidity is not in the sense of being stillborn, but in para 103, it says it's bereft of life. We leave that aside because, in fact, your lordships have held very clearly that no invalidity results. I'll come to that just a little later. I will make 2 points before I come to that. My lords have seen Hindustan Steel. The judgment in Hindustan Steel. And my lord, I've set this all out in my written submissions, pages, paras 32 to 47, so I'm not going to read it all. I'm running through this because much of this has been argued. I've set out the extracts from the judgments as well. Paras 32 to 47, starting at page 15. But I want to make one point. Hindustan Steel we have seen, and it is directly on point about curability. But there's another aspect your lordships may take into account. There's a judgment of your lordships in a totally different context under FEMA, in the Vijay Karya case, which my lords will find in volume 5A, page 1545. I'm not even asking my lords to go to that. But the principle in Vijay Karya's case is this. I've referred to it at para 37 of my written submissions. And the judgment is found at volume 5A, page 1545. Citation is 2020 11 SEC, page 1. The relevant page number? The page number is 1545, volume 5A. And at 1632 is para 88. Where your lordships have laid down a principle as to what happens when something is capable of regularization or post facto permission in the context of FEMA. This was that whole series of foreign awards coming. It's a general problem.
A very small niche point, which is that looking to the nature of Stamp Act.
Correct.
Are we required to look into Stamp Act at all under 11.6? So it should be left. This is all.
Yes.
Why should we go here and there on the issue?
Only to assist that conclusion that if it's a regularizable, curable defect, then your lordships, even in the context of other statutes such as FEMA, which also have a public policy connotation, have said the transaction is not voided. That's what para 88 says. The transaction is not voided because it's regularized. That's the only principle I want to cull out from Vijay Karya, but I'm not taking my note. I've set out, my lord, I'll just give my lords the reference in my submissions to the Singapore position on stamp expressly, my lord. My lord sees paragraph 80 of my submissions. Para 85 onwards, my lord, page 33. They have similar provisions. It's not that they don't. My lord sees para 86. (51)(1) of the Singapore Stamp Duties Act corresponds to our section 33, the impounding section. And section 52 in the next para corresponds to section 35. Same language. Not admissible in evidence, must not be acted upon. Identical language. And in para 88, I have referred to one decision of the Singapore courts, where it is categorically held that this is only a rule of evidence and does not affect the validity of an unstamped document. That is in this Muhammad Amin bin Muhammad type case. The case, I'll just state for the transcript, is found in volume 5B, page 4678. Even in NN Global, Justice Ravi Kumar at para 182 accepts that stamp duty defects are curable. Now, my lord, one other internal piece of evidence to show why the words shall not be acted upon can never be equated with voidness or invalidity. If those words were equated with voidness or invalidity, then there's no question of curing a void act. My lords put it to me. So the fact that you have provisions like 36, 37, 42 itself means shall not be acted upon in 35 can never be extended to an infirmity of invalidity or voidness. That's not what Parliament intended. Now, if my lords kindly go, and it will be very quick with this, my lord, page 19 of these submissions of mine, I've set out reference to a judgment of your lordships on this. Para 44 of my submissions. In Thiruvenkandam Pillai's case, Justice Ravindran's decision, 2008 for SCC 530, and I'll just read para 13, which I've extracted. It's in volume 5A at page 702. But I'll just read para 13 from here. The Stamp Act is a fiscal enactment intended to secure revenue for the state. In the absence of any rule requiring consecutively numbered stamp papers purchased on the same day being used for an instrument which is not intended to be registered, a document cannot be termed as invalid merely because it is written on two stamp papers purchased by the same person on different dates. Then the next sentence, even assuming that use of such stamp papers is an irregularity, the court can only deem the document to be not properly stamped, but cannot only on that ground hold the document to be invalid. Even if an agreement is not executed on registered stamp paper, it is admissible in evidence on payment of duty and penalty under section 35 or 37. If an agreement executed, so on. And the last sentence, but admissibility of a document into evidence and proof of genuineness of such document are different issues. Your lordships have held this under the Stamp Act. And para 45, I've set out the instructive judgment of the Calcutta High Court, which Mr. Banerjee also referred to, and Gulzar Lal. And the next para 46, a number of other courts, Bombay, Andhra Pradesh, Calcutta, have held this. It doesn't need to voidness or invalidity. So this is too well settled a proposition. I mean, Lord, I've just 2 points and I'll be done, Lord. One is, we have viewed this matter from the perspective of section 11(6), court appointment of arbitrators. But there is in existence a huge body of appointment of arbitrators by individuals. There's no dispute to start with. There's also increasingly growing in appointment by arbitral institutions. In fact, the policy of the law is to encourage the interposition of arbitral institutions. There's a proposed amendment which is not yet notified.
All those cases that will go before the arbitrator.
Correct. So I have also said,
Argument can be in 11(6), why take a different view than what would happen in?
That's right. And I'm obliged. The point I'm making here is your lordship's view on 11(6)(a) must try to harmonize even appointments by institutions.
With how arbitration in other areas, in other methodologies take place.
So, for example, all arbitration institutions have these rules. SIAC, for whom I appear, has rules 28.1 and 28.2, which essentially an objection as to jurisdiction, as to the existence of an agreement, can be initially raised before the full court. The court has the jurisdiction at that stage to knock out a claim if it is prima facie satisfied. Again, the prima facie test. Otherwise, it sends it to the tribunal for a fuller decision. And I may only ask my lords to mark 5 or 6 paragraphs of Justice Roy's decision in NN Global. That is paras 368 to 376, where he surveys the rules of several leading arbitral institutions. All of them have a prima facie test at the first instance. Para 368 at page 462 of volume 5A, up to para 376 at page 466. And he also refers to the Justice Sri Krishna report, which recommended encouragement of institutional arbitration. Because if my lords don't hold the prima facie test in 11(6)(a), then individuals and institutions will be left in a quandary. What do they do? Because the observations in NN Global, albeit in the context of section 11, will apply to them as well. If it is held that an unstamped agreement is void, what do they do? Now, one further problem. Neither individuals nor arbitral institutions are empowered to receive evidence. So they would not be covered by the bar under Section 35 of the Stamp Act, because that only applies to persons who are authorized to receive evidence either by consent or by law, or indeed they would not have the power of impounding under Section 33. So they can't impound. There is no bar under 35, but there's your lordship's decision in NN Global saying void and non-existent. So they are in a complete quandary as to what to do. Therefore, it is important your lordships decide this matter holistically, because otherwise a very important segment gets left apart. And there I must say, my learned friends, I've had a cursory look at their submissions. Mr. Shyam Devan, I'll just note it for the transcript in para 4.7 of his submissions, accepts that arbitral institutions have no power to impound, but they might be able to appoint a tribunal because Section 35 is not applicable to them. And Mr. Nakul Devan at para 23 also says arbitral institutions have no power to receive evidence. Equally, Mr. Shyam Devan at para 4.7 agrees that an arbitral tribunal has the right to impound a document under Section 33 because it is authorized to receive evidence by consent of the parties, not by law but by consent of the parties. And therefore it can impound under 33, which is my submission as well. And one more reason why it should go to a tribunal. And Mr. Nakul Devan at paras 24 and 25 finally comes around to the same view that even under 11 your lordship should be pleased to refer it to the tribunal. Mr. Shyam Devan raises the point that it may not be convenient for an arbitral tribunal to do this. It doesn't have the infrastructure to impound, send the document to the stamp authorities. But that's an issue of convenience. It's not an issue of law or jurisdiction. But I leave it to my learned friends to satisfy my lords why it should not be sent to the tribunal. Now, one point and then I'll draw my conclusions very briefly, Mara. I'll just give the pages because it doesn't arise before my lord, but it puts the matter in perspective. Paras 48 to 58 of my written submissions, pages 21 to 24, deal with this whole issue of who is entitled to impose stamp. Does it come under list 1 and therefore under the Indian Stamp Act?
You need not go
That's
into
right.
that actually.
They're not required to
They're
go
not.
at all.
We
But
saw those entries,
that's
so
right.
you don't have to go into.
I only wanted to say one thing and I'll be done with this. Under the state stamp acts, the residuary articles have stamp duty of 50 rupees and 100 rupees. Now, the process of arbitration ultimately cannot be held up for 50 and 100 rupees, which can easily be cured because all the residuary articles are low figures. NN Global, I'm not going to analyze again. My learned friends have analyzed it. I don't. Not just my conclusions. First is that your lordships should be pleased to adopt a purposive interpretation to uphold the intent to arbitrate. In deference to party autonomy. And I've given some cases where your lordships have done that under the Arbitration Act in Nandan Biometrics, etc. I've mentioned them in my written statement. The second is Section 5 of the Arbitration Act must be given full effect. It's a very wide non-obstante. And the Arbitration Act is a complete code. Your lordships in the Amazon case, I'll again just give the para number, para 43, and the judgment is found in volume 5B at page 623, have held that the new Arbitration Act with the amendments is a complete breakthrough from the old position. Therefore, every provision of that act must be interpreted given the overarching principle of Section 5 and the principle of an implied negative competence. The third, as held in Vidya Drolian, that so long as an arbitration agreement satisfies the requirements of the Arbitration Act ex facie by adopting the prima facie test, there's no question of a court holding up the arbitral process by entering into an examination of whether duty is paid, whether it's understamped, under which article it falls, etc., etc. The fourth, since a tribunal is authorized to receive evidence Section 33 of the Stamp Act will apply to it squarely. It can impound the document and start the process of stamp collection. There's no reason why a court, courts are already clogged with so many matters, why they should be clogged up into this. Fifth, such an interpretation of 11(6)(a) will also harmonize the process between appointments by courts, by individuals, and by arbitral institutions. An arbitral institution certainly will take just a prima facie look before the tribunal is appointed. An individual may not do that. The one who wants to refer to arbitration will refer, the other one will go to Section 11. So it's unlikely, but sometimes individuals do, because very often these objections are raised halfway through an arbitration. So it's not unheard of. Then, my lord, 6, the trend is towards encouraging institutional arbitration. The Amazon case has said so, and your lordships are familiar with the Sri Krishna report, which has said so. And therefore, to leave institutions in a quandary and to effectively block the process of institutional appointment by saying go into stamp objections will not subserve this broader public policy objective. And lastly, there is also a trend towards investing arbitral tribunals, a parliamentary trend, towards investing arbitral tribunals with powers of a court. This is the legislative prescription of Parliament. I'll give a few examples. The amendment adding 17(2), which prevents a Section 9 court, which effectively prevents a Section 9 court from giving interim reliefs, because under 17(2), the orders of an arbitral tribunal are given the force of law of orders of the court. And corresponding provision is 9(3). Section 11(6)(a) itself. Section 8 was amended in 2015 to include prima facie, to bring it into line with 45, where under Shinitzue, your lordships had held only a prima facie look to a foreign arbitrations. And even 12. Under Section 12, even impartiality and independence, the first objections must go to the tribunal itself. So the whole trend is empower the tribunals more and more in deference to the principle of competence. And this, in my respectful submission, will subserve the scheme and object of the Act, minimum interference of courts, party autonomy, and one-stop adjudication. And ultimately, in a lighter vein, this might encourage the stream of trade and commerce, and ultimately more stamp duty might result as a result of this, rather than holding it all up for stamp objections to be decided by courts. I am deeply grateful for the time I've been given.
Who are you appearing for now?
My lords have been grateful when I was appearing in the Constitution bench for inviting submissions. So 5 to 7 minutes, my lord.
Just one thing.
Yes.
We have to wrap up the proceedings today.
Yes.
It may not be in the interest of anybody that, we leave it on.
I understand.
So what we'll do is, we'll look at the submissions of all the interveners.
Yes.
Would have much liked to hear you all. You've put in a lot of industry. Please rest assured, we'll read all the submissions of the interveners. If we have something at the end, in response to what Mr. Diwan has argued, and since we have heard Mr. Datar, Mr. Gaurav Banerjee, and Mr. Daraz Kambata on this side, in rejoinder, if we have some queries, we'll put them to the intervener. I think that may be better.
2 minutes for one aspect.
We can't give 2 minutes to everybody. Thank you. Yes, Mr. Diwan. We'll try. Do this. Give us your submissions. Yes, Mr. Diwan.
We've narrowed down the controversy, Gaurav. Therefore, there's really nothing to be added.
Nothing to repeat. Only then I would just have pointed out the relevant pages of my written submission. That's all.
So that we'll read it, don't worry. We'll read it in.
Thank you. Yes, we'll read the submissions. Yes, Mr. Diwan.
I appear for respondents 1, 2, and 4. I appear with Mr. Nikhil Nair. We will divide our submissions. For respondents 1, 2, and 4. I'll request the court master. Yes,
Diwan, one thing, since we have now renamed the title of this proceeding, the object was also to assuage your concern on behalf of your client that we shouldn't look into the curative aspect. or that you have a preliminary objection to the curative issue.
Yes.
We'll be sending it back to
Yes,
the
but that may
five-judge
not,
bench on
so
the
that
curative.
after hearing us on curative, your lordship may consider whether that's the correct course at all. Because in my respectful submission, that may not be the correct course.
We
So I'll
really
be
want your
brief.
we want your assistance on the question of law.
I'll do that as
And-
much as I
and
can,
justice-
but it will do that in two
Justice to
stages.
your client on facts and whether curative should be exercised, we'll leave it to the five-judge bench, and we are not going to come
Because
in the
you
way
may-
of your
you may
client
certainly-
saying that, look, please dismiss this curative because they have no case on merit.
Yeah, I think, okay, so let me,
the meaning of
I've understood what your lordship is indicating. Now let me contest that position and suggest that there is a better way forward.
Yes.
So let me first, so I am going to be making my submission very rapidly because of the constraint of time. I will state my points. I'll request the court master, if you consider it convenient, to hand over, I've given a list of the Constitution of India, the Stamp Act, the Arbitration Act physically, because it may take less time that way, that they may.
We have it with us.
Now, let me just, so I have two broad sets of submissions. I have two broad sets of submissions. I am first setting out my points with regard to my first set of submissions. The first submission is that our court, which is the Supreme Court of India, as we understand it, is a means and ends institution. We are very particular about means and ends when it comes to courts below, when it comes to government authorities, when it comes to citizens, and most important, when it comes to ourselves. Because the reputation and credibility of our institution rests on the foundation that we reject expediency. We do not. We have sometimes very honorable objectives, but we do that as the apex court in our country, following, reaching those ends by permissible means. And that is going to be my first point with regard to means and ends, the importance of means and ends, and the importance of the nature of jurisdiction which your lordships is exercising. That's my first point. I now come to my second point. Let me indicate what we are not exercising first. So first and foremost, as your lordship correctly put to me, that look, we have relabeled this, and I'm very grateful for that because I think it really helps, because the parties know, individuals who read the judgment know. So I think it's very beneficial to have an appropriate caption for the case rather than this. But the caption and altering the caption, does it alter the nature of the jurisdiction which you are exercising? So I ask myself a simple question. What are the jurisdictions which this court indeed does exercise? Are we in the realm of appellate jurisdictions? The answer is no. It's not appellate constitutional. It is not appellate statutory. Is it review jurisdiction? The answer is again no, because review, as I will indicate to your lordships, has been rejected. Are we in a jurisdiction which is original like 131 or 32? The answer is no. Are we in a jurisdiction of discretionary appeal? The answer is no. Are we in a jurisdiction on an opinion which the President of India seeks by way of a reference? The answer is no. Are we in a transfer jurisdiction? The answer is no. So then what is our jurisdiction? What is this panel constituted exercising? There must be jurisdiction. This is the primary function of every court. You must be satisfied. I'm only saying that. You ought to be, I can't say must be. You ought to be satisfied that the jurisdiction which you are exercising in a panel of seven, I'm sorry.
Where a 5 judges constitution bench has found the view taken by earlier 5 judges bench.
Yes, yes.
To be prima facie not correct.
Correct.
Is a reference to 7 judges not called for?
Yes. So let me answer that straight away. If in an appropriate jurisdiction, I answer that straight away. If in an appropriate jurisdiction, your lordship's exercising a jurisdiction, your lordship finds that a 5-judge bench is not appropriate prima facie or otherwise, by all means you have the power to do so. So I concede and I accept that. But not in the curative jurisdiction. Now I'll come, so let me answer that question straight away first.
The only problem is,
Yes,
exactly.
I'm so
That
sorry.
doesn't-
Sorry.
that doesn't-
No, there are fundamental issues. I'm sorry.
That doesn't really survive, subject to what you say.
Yes, yes, of course.
Because even when you were arguing earlier,
Yeah.
you said this is not a case for curative.
Sorry.
This is not a case for curative.
That's my submission. I mean, it's ultimately for the court to hold.
Case for curative,